The version most people remember is simple. An elderly woman spilled coffee on herself, sued McDonald's, and walked away with millions. Almost every useful fact disappeared from that sentence. Stella Liebeck suffered full-thickness burns, initially asked only for her expenses, and never received the famous $2.7 million. The real question was not whether coffee should be hot. It was whether McDonald's knowingly served coffee at a temperature that made an ordinary spill catastrophically dangerous. That question sounds rather different from the joke, which is precisely why the joke survived. Liebeck was 79 years old when she bought a small coffee from a McDonald's drive-thru in Albuquerque, New Mexico. She was sitting in the passenger seat while her grandson drove. After receiving the order, they parked so she could add cream and sugar. The car had no level cup holder within reach, so Liebeck placed the cup between her knees and tried to remove the lid. The cup tipped, and the coffee poured into her lap. She was wearing cotton sweatpants, which absorbed the liquid and held it against her skin instead of letting it run away. The result was not a red patch, a blister, or an embarrassing afternoon. Liebeck suffered burns over roughly 16% of her body, including full-thickness third-degree burns over about 6%. The worst injuries affected her inner thighs, buttocks, and groin. She went into shock, spent about a week in the hospital, and underwent skin grafting. Her recovery required additional treatment and assistance from her daughter, and the injuries left permanent scarring. This was the human fact that most punchlines carefully removed. Liebeck did not begin by demanding a jackpot. She contacted McDonald's and asked for approximately $20,000 to cover medical expenses, expected treatment, and her daughter's lost income. McDonald's offered $800. That offer did not cover the medical bills already incurred. After the parties failed to resolve the claim, Liebeck hired lawyers and filed a product liability lawsuit. By the time the dispute reached trial, the positions had hardened considerably. Liebeck argued that the coffee was not merely hot, but unreasonably dangerous at the temperature McDonald's required. She also argued that the warning on the cup did not adequately communicate the risk of severe burns. McDonald's answered with a point that still sounds persuasive to many people. Coffee is supposed to be hot, and Liebeck had spilled it on herself. The company did not pour it into her lap, hand her a broken cup, or cause the vehicle to move. McDonald's also argued that customers wanted hot coffee, and that high temperatures help preserve flavor during brewing and holding. In other words, the defense was not absurd. The law does not make a company automatically liable whenever a familiar product causes an injury. The jury had to decide whether the coffee was in a defective condition and unreasonably dangerous under the circumstances. It also had to consider whether Liebeck's own handling of the cup contributed to the accident. That second issue mattered because New Mexico used comparative fault. The jury could hold both sides responsible and reduce any compensation by Liebeck's percentage of blame. So, the case was never a choice between a completely helpless customer and a completely innocent restaurant. It was a dispute over how much responsibility belonged on each side. The evidence that changed the case was McDonald's temperature policy. The company required its restaurants to hold coffee between roughly 180 and 190 degrees Fahrenheit. At that range, expert testimony indicated that spilled liquid could cause full-thickness burns within seconds. A lower serving temperature could still burn someone, but it generally allowed more time to remove soaked clothing or wipe liquid away. That difference mattered because Liebeck's sweatpants trapped the coffee against her skin. The plaintiff also presented tests indicating that coffee from other local establishments was commonly served at lower temperatures. McDonald's disputed the suggestion that its practice was outside the relevant industry standard. Its lawyers emphasized that hot beverages everywhere can burn, and that no serving temperature makes careless handling harmless. Then came the company records. During the decade before Liebeck's injury, McDonald's had received nearly 700 reports of customers being burned by its coffee. Those incidents varied in severity, and McDonald's had resolved some claims with payments. To Liebeck's lawyers, The record showed repeated warning that the policy could produce grave injuries. To McDonald's, the same records proved something nearly opposite. The company sold billions of cups, and its expert calculated roughly one burn claim for every 24 million cups served. Statistically, McDonald's argued the injury rate was extraordinarily small. This was the most serious defense in the case, not the slogan that everyone knows coffee is hot. Businesses cannot eliminate every risk, and rare accidents do not automatically prove that a product is defective. The plaintiff's response was that frequency was not the only question. The company knew the possible injury was devastating, knew similar burns had occurred, and maintained the same temperature policy. A tiny percentage can still represent real people, especially when the consequence is skin grafting rather than mild discomfort. The warning on the cup became part of the same dispute. It indicated that the contents were hot, but Liebeck argued that it did not warn customers about the speed and severity of the scalding risk. McDonald's could reasonably say that a coffee cup should not need an essay explaining that hot liquid burns. Liebeck could reasonably answer that ordinary heat and near-instant full thickness burns are not the same warning. The jury ultimately accepted more of Liebeck's argument than McDonald's. After hearing the testimony and seeing photographs of the injuries, the jurors found McDonald's 80% responsible. They found Liebeck 20% responsible for causing the spill. That allocation is usually omitted because it ruins both extreme versions of the story. The jury did not declare Liebeck blameless, and it did not treat McDonald's as responsible for every hot beverage accident. It concluded that her mistake caused the spill, while the company's policy made the consequences unreasonably severe. The jurors awarded $200,000 in compensatory damages for the actual harm. Because Liebeck was 20% at fault, that amount was reduced to $160,000. Then, the jury considered punitive damages, which serve a different purpose. Compensatory damages address the injured person's losses, while punitive damages punish and deter especially blameworthy conduct. Liebeck's lawyers focused on the prior complaints and McDonald's decision not to change its temperature policy. They suggested using approximately 2 days of McDonald's coffee revenue as the measure. The jury awarded $2.7 million in punitive damages. That number became the headline, despite not being the final amount and not representing payment for Liebeck's medical bills. The trial judge later reduced the punitive award to $480,000, bringing the reduced total to $640,000. In doing so, the judge still described McDonald's conduct in terms such as willful, wanton, and reckless. Both sides pursued further review, but no appellate court issued a decision resolving the merits. Instead, the parties reached a confidential settlement. Because the amount remained confidential, nobody outside the agreement can honestly claim to know exactly what Liebeck received. A source later told Retro Report that the settlement was below $500,000. What is certain is that she did not receive the $2.7 million repeated in jokes, speeches, and television segments. The legal system had already reduced that figure before the cultural story finished inflating it. The first detailed local report contained enough space to explain the injuries, evidence, defenses, and damage calculations. As wire services and television programs compressed the case, the account became shorter and less accurate. Some reports even suggested that Liebeck was driving with the cup between her legs when the car was actually parked. The story was reduced to 3 ingredients: woman, coffee, millions. Without the burns, the temperature policy, the prior complaints, or the judicial reduction, the lawsuit looked ridiculous. That simplified version was useful to politicians and organizations campaigning to restrict civil lawsuits and damage awards. Liebeck's case became a symbol in the national debate over tort reform, often presented as proof that juries had lost perspective. The actual jury, inconveniently, had spent days hearing evidence that the public usually received in a few sentences. Correcting the myth does not require pretending that McDonald's had no legitimate defense. 700 complaints among billions of cups can support an argument that the product was overwhelmingly used without injury. It can also support an argument that the company had years of notice about a preventable pattern of severe harm. The jury was created to choose between those interpretations after seeing the evidence, not after hearing a late-night monologue. The case also did not establish a national temperature limit for coffee. It did not make restaurants liable whenever a customer spills a hot drink. It did not produce a binding appellate precedent because the parties settled before the appeals were decided. It was a state trial verdict based on one company's policy, one warning, one injury, and one evidentiary record. Retro Report later found franchise handbooks requiring coffee to be held and served roughly 10 degrees lower. Yet, the case's larger consequence was not a neat new rule printed in law books. It was the creation of a legal myth, powerful enough to influence jurors who had never seen Liebeck's evidence. In 2011, the Utah Supreme Court ordered a new trial in an unrelated injury case after a lawyer invoked the McDonald's coffee story to discredit large damages. The court concluded that the reference carried a reasonable likelihood of prejudicing the jury. That is an extraordinary afterlife for a case that produced no appellate opinion of its own. Stella Liebeck died in 2004. Long after her name had become shorthand for a lawsuit the public rarely understood. She did not receive millions simply because coffee was hot. The evidence persuaded a jury that McDonald's knew its chosen temperature could turn an ordinary spill into a devastating injury within seconds. Liebeck's own responsibility reduced her compensation. The judge reduced the punishment, and settlement ended the appeal. The famous story says a woman became rich by failing to respect hot coffee. The record shows something less convenient: a severe injury, a disputed corporate risk, and a headline that outlived the facts.